At your former Kwaba de Likee TV, no Mrs. and our channel so hit Akroma subscribers and dropping the latest news content about Jabre. Now was it Maccabi. Now your Bora and 70 ma 84 say and semi Bobo Bano. Reporting Saka say it me who say after their ruling in NPP 4 so more attack the NDC Caucus on there was reporting in Semeti that the Constitution no Supreme Court of Fortune so may interpret it no James ate wo masiu Bagbin e wo kwan so ina emunsem etesei mpese yebowram na yetie mo no ensem yeba de ka ho no yedi munsem bebram.
No, that is what the applicant is saying. I don't know.
And I get it. But the point I'm trying to say, the Haruna Idrisu statement cannot be a cause of action.
No.
Oh. No. So if there's no cause of action, at the time the suit was filed, the Supreme Court had no business listening to him.
No. Because what would trigger the cause of action will emanate from the Speaker's remarks. I
see. So please go ahead.
Yes.
So I wanted you to tell me your understanding of what Justice Tanko is saying.
Yes. So Justice Tanko is saying that majority, but I must say that the majority, the concurring opinion, the dissenting opinion, all three are fantastic.
Okay.
Fantastic, very refreshing. For once, we didn't have, a sensational headline. Supreme Court bounces. For once, we have, we don't have a unanimous, but we have judicial minds espousing the law, telling us where, and it's a reminder that yesteryears we did have the judges who could deliver themselves of, what the majority, the concurring, and the dissentient delivered. Great judgments.
I see.
Food for thought. Whether we may not like the conclusions, but let me try to situate the problem that confronted the Supreme Court.
I get it. But before you go ahead, I thought, when I was reading the Justice Tanko's thing, there was a portion where he said that the court is not a court where academic or fanciful issues which are not live are dealt with.
Sure.
It is based on what you just said, which is there was no cause of action.
Sure.
So what do you file in court? So that's what he meant.
Sure.
Okay.
So if you are sitting, if you are a sitting judge, please, don't put your ears to the ground and listen to what the law teachers, the law students, the legal, politicians, but you have a live matter in your hand. What is the position of the law?
That's all.
That's Tanko's approach.
Okay. So you're trying to set a context.
Yes.
Before I go to Hamza and
yes. So the issue is this. If you look at the rate, what was the plaintiff asking the Supreme Court to do? Now, Dakwesare, who spoke for the majority, if you look at page 2, the first paragraph, which is the concluding, remarks of the first, last paragraph, page 1.
Yes.
He made it quite clear that on the 17th, when the Speaker's conduct or act complained of arose, these people had already, commenced the action on the 15th. That is where he himself, as well as the majority, had a problem. You have come to us. What is your, prayer? The prayer must be grounded on something. That something was not there. So they kept struggling to find that something on which to anchor their conclusion is not there. Therefore, when we ask ourselves, did the majority make any consequential orders? Consequential orders on what? They couldn't have. They simply could not have made any consequential orders.
So there should have been an amendment to the rate?
They should have thrown, out the plaintiff.
The plaintiff.
Because the rate was not even accompanied by, under the rules, it should have been accompanied by an affidavit verifying the facts alluded to, in the statement. Okay. There was no such rate. So it was incomplete. If it was incomplete, the jurisdiction of the Supreme Court couldn't have been properly invoked.
I see.
Number two, under the Constitution, the Speaker ought not to have been joined. He ought not to have been sued at all. If you sue the Speaker, it is the Attorney General who must constitutionally defend it. Therefore, when the suit was commenced against the Speaker and the Attorney General, the approach of the Supreme Court should have been, well, applicant, we realize that you have added the Speaker. Are you aware that constitutionally it is only the Attorney General who can defend unless we grant leave joining the Speaker, and then the Speaker will become, a party properly joined to the suit? The Supreme Court did not do that. The Supreme Court rather hastily accepted a writ on its face as though it was a writ properly filed. It wasn't. So I have a fundamental issue, there. If the Speaker, if the Attorney General is to, which it is within his province to state that I am the defender, why bring in the Attorney General? He's right. You see, so there again, it was fundamentally defective.
Okay.
So it created a situation where you brought a party who had been improperly joined to the suit. And if you look at the majority opinions, we're all grounded. The first speaker said this, the first defendant said that, the first defendant said that. When the first defendant came to court on the 28th, the affidavit in support, of the application to dismiss the suit, we're all wrong. Because they were attacking a party who was non-existent. They were attacking a party who was non-existent.
Party.
No.
To the suit.
No. It's only the Attorney General. Now, the question is, on the 15th... But the Attorney
General then became a second defendant to the plaintiff.
Yeah, but the first defendant was improperly joined.
Okay.
Under Article 88, Clause 5 of the Constitution, it is only the Attorney General who shall defend suits against the state. And the Speaker is part of the state. Period. Now, when you have, that kind of problem confronting you, what do? Procedurally, the Supreme Court has every right to order the Speaker to be properly made a party.
Okay. Seeing
the potential conflict of interest, if the Attorney General were allowed to represent the Speaker, there's a potential danger, and it's a threat to our democracy. Right. Therefore, the Supreme Court will say, well, Mr. Attorney General, let's begin with the plaintiff. Plaintiff, we have looked at your application for stay of execution filed on the 17th. Well, we are unable to consider and grant, your relief today.
Okay.
Please, it is ex parte. It is without notice to the other side. The person, you have notified the Speaker is not the person, who should have been attacked by the plaintiff. Therefore, we are going to make an order that the applicant should bring the defendant to court, that is the Attorney General, on notice.
Oh, okay.
Without granting any 10 days or 100 days or no, they shouldn't, because under the rules, when the application comes for hearing, the court will do one of several things. Either grant or refuse,
okay, or
give, set directives as shall conduce to, justice, as the justice of the case requires it. That's what they should have done. Okay. They didn't do that. That is why Sorry is saying that when you look at it, fundamentally flawed. The facts were wholly unmeritorious. Why were they wholly unmeritorious? Because the act that occurred on the 17th hadn't occurred on the 15th. So factually, it was without merit. If the writ was not accompanied by the affidavit of verification as required by the Supreme Court rules, then it meant that it was incompetent. The Supreme Court had an incomplete process on their hands. So what the Supreme Court should have done was, look, go and put your house in order. We cannot accept it as it is. Now, putting their house in order necessarily meant curing the deficiency. And what was that deficiency? That the rate did not contain any reasonable cause of action. Don't blame them. On the 15th, the cause of action hadn't arisen. But on the 17th, when the speaker made a communication, that triggered the cause of action. Therefore, as of the 17th to date, the applicant or the plaintiff should necessarily have amended the rate. As we speak, they never amended the rate. So the Supreme Court had a defective rate on its hands. Why then did they proceed? Because as a law teacher, and this is a fantastic judgment for law teachers and law students, because we have a lot to engage our students on.
As far as this judgment is
exactly. Were they right?
But if you listen to the Chief Justice and her concerns and worry that Parliament is not sitting, can you not understand why we had to sidestep a few of these things? Just we want to hear the matter. The technicalities can wait. The Chief Justice told us that she's concerned that Parliament is not sitting.
Yeah, but it must be according to law.
Okay.
Whatever the Chief Justice is saying, must be according to law.
Okay, I get that. I don't know, Hamza, do you want to look at the jurisdictional question, or you want to look at what this ruling means, especially when it comes to being internal party discipline? No, sorry, to be fair, I need to go to Ishaq, because Ishaq. Let me go to Ishaq so that Hamza will come. Or you want Hamza to go? Oh, he was right. You know, they are brothers, so I want to be sure I don't clash two brothers, Hamza. Yeah. Hamza, so I don't know so where do you want to look at? You want to look at the jurisdictional question, or you want to go? Oh, that's fine. In fact, I was talking to, what's the name of this guy? Frank Davids, on my show on Wednesday. His biggest problem was the fact that Thaddeus Sori failed to file a statement of claim and his memorandum of issues in court, and he thought it was a serious disrespect to the court as far as Frank Davis is concerned, and also even the Attorney General is concerned. I don't know whether you want to touch on that briefly, whether you agree with him, and before you go to the more substantive.
I think we don't have time.
All right.
I'll touch on it at some point, but I want to base here.
That's fine.
I'm sorry, I'm going to disagree with my friend here.
Okay.
And hopefully,
Mr.
my boss.
Okay.
And you know why.
That's why we're here.
I've read the judgment. Even though sometimes some of the reason of the majority, I may have disagreement. But I totally agree with the conclusions reached. With regards to both jurisdiction and the interpretation of Article 97 as well. I'll touch on the jurisdiction briefly.
Okay.
Yes. I think the concerns raised by a former director of Ghana School of Law, the court picked it up. The court, as the court said, on the 15th, when the case was filed, if nothing had happened after the 15th, they would have declined jurisdiction. It's very clear in the case. But then on the 17th, something happened in Parliament. And it was brought into their notice by Afenyo Markin when he applied for the interim order. That was when they picked it up. And because the interim order, they more or less used their discretion based on the interim order that was filed. And the fact that a complaint was made on the 15th. And the complaint intimately allows them, because of their jurisdiction, that they have under Article 130 and Article 2 made them to exercise discretion to accept it. In other words, the events of the 17th and the formal report that was made to them in the form of request for interim injunction allow them to use their discretion to accept the substantive case that was filed on the 15th.
Okay.
Good. And this is the reason why, even though I don't like Justice Tanko's conclusion, but some of his analysis I accept it. Yes. That's why I said I don't like his conclusion. But the way he analyzed the law, I accept it. In fact, when I read judgment, I look for the legal theory. The legal theory give us the justification as to why a judge might decide this way. Yesterday, I was talking about how legal theory enrich judgment, and some of my NDC colleagues were disagreeing. Then I come to realize that Justice Tanko, Hamza, I just want to mention Hamza. Hamza was disagreeing. Right. Then I come to realize that Justice Tanko have actually done it in arriving. When he quoted this quoted debate between Professor Hart and Lloyd Fuller, talking about whether procedure could be sacrificed sometimes for substantive morality. And he was talking about how Fuller used it. So if, for example, I want to borrow the theory that he has just deployed with Fuller, should we use procedural breaches to kill off a case, even though substantively there is an issue? I'll probably say no. And this is why I agree with the court to use that particular discretion, that a small procedural defect that does not go to the heart of the complaint should not be used as a basis. And now let's come to look at Article 130 and Article 2. Does the Supreme Court have jurisdiction, assuming there was no procedural breaches that they could have used their discretion to kill? I believe there is. Why do I say so? Because Article 130 and 12, if any market was knocking their doors to use their interpretive power granted to them by the Constitution under Article 130, and as well as their power to make orders or declare under Article 2, to interpret Article. The rule is the ordinary people who look at core meaning of words will say you have breached it. Because the rule says no car in the park. And you have breached it. And therefore, such a person is going to go to prison. If you are very strict with this particular rule, you are going to send a lot of innocent people to prison if you think the meaning is clear. In his theory, in Professor Hart's theory, he made it clear that in every rule that is made, there is a core meaning, and there is something we call penumbra meaning. The penumbra meaning is the meaning you get after you interpret that particular rule. So, for example, let's say no car in the park. If you follow the core meaning, what will simple mean is that, yes, somebody who wants to take a shortcut by passing through the park to save time could be sent to prison. Some people might say, that's fine. The rule was focused on people of that nature. What about if an elderly person goes inside the park and collapses, and you call an ambulance to come and save such a person? If the ambulance goes in, if you use a call meaning, the ambulance driver.
Yeah, the massive some of Jebre so what daily update TV so.